1.1, investments are managed in accordance with all applicable laws, trust documents, and written investment policy statements. I went over this quite a bit in the last slide. What's important here is section 1.1.4, the investment management process and filed in a centralized location. This does not mean, but it often translates to, I have a file in a desk somewhere, papers are coming out, all catty-cornered, and that is my 401k retirement plan file. The Department of Labor would love to visit with you. We want to make sure that we have binders, they are dated, they are broken up with tabs as to the various sections of our plan, and that they're easily accessible. They are looking for disorganization. They are hoping for disorganization. A little effort goes a long way in this regard. These are the types of plans and what act applies to them. As I mentioned before, ERISA is the 900-pound gorilla that has so much in it that it pretty much talks about child rearing in one section. We try not to go into that section, but if you have a corporate retirement plan, a defined contribution, which is a 401k, a defined benefit plan, Taft-Hartley, or employee welfare. Who oversees, who comes in and is the heavy in that regard? It is the Department of Labor, the IRS, and the Pension Benefit Guarantee Corp. We don't necessarily, MPERS is one that would be apropos to public retirement plans, and those are overseen by the State Attorney General. We don't necessarily need to pay attention to UPMIFA and UPIA, just because those are for foundations and other types of trusts. Does anybody have any questions here? Anybody asleep? No? Need to take a break, take a walk? Let me know. So, what are the key tenets of fiduciary responsibility? You think that you just put this plan in place and after that comes the flood. You have a duty of loyalty and it is undivided. And you would think it is to my employer. I work for so-and-so. Actually, as a fiduciary, you were there. This is where ESOP plans get into a lot of trouble. You need to act for the best interest, or in the best interest of those that are participating in the plan. If your employer were to come to you and say, get the cheapest, the whatever it is, make it work, do it, and it is not in the best interest of your participants, you are on the hook. You cannot say I was just following orders. You have to document any type of situation where there is discordance as to who is in the plan, why they are in the plan, who is sponsoring the plan. All things should be documented. You have to act in utmost good faith. Your child, neighbor, brother, sister may be a broker, but unless you have some policies and procedures in place that indicate this is how I have found him, this is why we selected them, you can't use nepotism as a reason for plan selection. It should be because it's in the best interest of your participants. Prudent expert standard. I mentioned before that if you are in an advisory role, you have the prudent man rule, where I promise to work in your best interest. You now, as a fiduciary, have accepted the prudent man rule as well. Process trumps outcomes. It doesn't matter if you have the most fantastically performing 401k in the world. You need the documents. You need that articulation. Protect yourself, protect yourself, protect yourself. If an advisor has said that they have promised you the moon and said that they are co-fiduciaries, say, I'm delighted to hear that, and I'm glad we're all friends here. If you'll just sign this paper indicating that you are accepting co-fiduciary status, and we'll see how friendships change and shift after that. It's business. It's all that it is. Any documentation that defines the fiduciary process. When you start and have a 401k program, you have trust documents that are associated with that. You are opening essentially a trust account that is for the benefit of others that you are administering. It is as if you are opening a brokerage account for a 5-year-old. They expect you, as a position of fiduciary, to make decisions as if the people that you're making decisions for can't do it for themselves. Part of, most people get the custodial or brokerage statements that are associated with their 401k, throw it in a file, hope for the best, and forget about it. They need to be in a big folder, broken up by tabs, broken up by year, separated out. Your investment performance reports. Most of the time people look at it, get that glazed look, and again, stick it in the folder. You need to have a continuing dialogue with your service provider to make sure that what kind of investments do we have in the plan? Are they cost effective? Are they working for the demographic that we have in our plan? If we have only aggressive funds, that the Las Vegas accounts, if you will, and you have 50-year-old employees, 60-year-old employees, you are actually violating your fiduciary role by not having within the plan something that is appropriate for those that are participating in the plan. IPS and committee minutes. The investment policy statement, as I said before, is a business plan for your 401k, for any retirement plans that you have. Any discussions that take place concerning the 401k need to be documented. Spoke with Owner Jr. Owner Jr. has indicated that he wants to do X, Y, and Z with his personal Bob broker. And then you can bring to Bob Jr. or Owner Jr. We can't. That's not in our investment policy statement. We would love to have Bob Broker. He needs to submit a request for, or he needs to respond to one of our requests for proposals or a request for information. Most recent asset allocation study. This is where the art is in selecting the right advisor, and where a lot of plan administrators lean heavily on their advisors. The world changes every single day, sometimes without notice, oftentimes without notice. Plan assets do that as well, and we need to make sure that what's within is A, cost effective, B, attuned to the participants that are within your plan, and C, that it's still appropriate. Do we have enough given our growth? Do we have enough opportunity within? With that, we started off with 20 employees. We are now at 400 employees. Is this the right type of plan? Are we filing correctly? All of these questions you are responsible for, and that's where the homework, the documentation is so important. And then the monitoring procedures. Ignorance is not a viable defense. I didn't know. Nationwide is doing it for me. Schwab is doing it for me. The Department of Labor, the IRS, they do not care. They love to hear that. If it is not in writing, you are on the hook alone. How's everybody doing? We are actually coming up to the hour. I'm going to let you guys take a little bit of a break so I don't ear beat you the entire time. So you can run to the restroom, get some coffee, get some donuts. 10 minutes work for everybody? We'll come back at about 9:10. So the questions that I got asked during break that could be important to everybody is, if my company has, through their officer's policy, fiduciary liability, does that cover me? Yes. What's traditionally wrong with fiduciary liability is that most officers don't have, or the policies tend not to be comprehensive. Fiduciary liability policies are incredibly important if you have a 401k. It is really important if you have an ESOP plan. ESOP plans, the Cliff Notes version of that is if we have a company, I have a trucking company I plan to sell, but my children don't want to take it over. I sell it to my employees and get the money out of the business. And then the employees essentially become shareholders of that company. Because of the contractions within the economy that have happened in 2008, 2009, ESOPs are evaluated or valued each year by an independent accountant, and then your basis within your ESOP is determined by that valuation. So if business is bad, your ESOP valuation is poor. Traditional business is bad, you may also have to let employees go, employees that may be shareholders. So not only are they not happy about being let go, they're not happy about the balances that are available to them in their profit sharing or their ESOP plan. So long answer to your short question is yes, it covers. Make sure that the policies are comprehensive. And if you have an ESOP and a 401k plan, make sure that they are bolstered up enough to where they are covering you completely. And traditionally with fiduciary liability, it tends to only cover legal fines, not personal fines. So those those are things to take a look at.
And some won't cover fines at all.
Yeah, some of them won't cover fines at all, so this is an area where it would bear taking a look at and making sure.
They'll cover defense
Yeah,
only.
they will cover your legal fees, but in the example of the medical practice here, the $600,000 worth of fines were out of pocket.
That's different from the award that maybe the employee got because of it being non-compliant. So you got fines and awards that go to employees, and depending on the policy, usually it just covers the award, not the fines itself. It only covers defense of those fines.
So if an ESOP is non-contributory from the employee, strictly in management, it's still being that it's defined.
Yeah,
It's
I mean, and
still under all that
ESOPs,
stuff.
and those that are overseeing ESOPs, they are tremendously trickly beasts, and the IRS loves them because they have been abused in the past. If you are overseeing an ESOP plan, sometimes you're like, all of my gray hair, ESOP plan administration. They are nasty. And then a lot of times the advisors that you have associated with it are attorneys that speak nothing but Greek to begin with, so it makes it very difficult for you to understand. Okay, boss, what do I actually need to do? Tell me in English. A lot of times that doesn't happen. So, and if you have questions in particular, offline, because I don't know how many people have ESOP plans here, but I could bore you completely to sleep if you would. Did anybody else after the break have any other questions, anything that came to them? Otherwise, onward and upward, ladies. The next question is, who are fiduciaries? I think we've got a pretty good handle on pretty much if you can be on the hook, you are on the hook. But who is not a fiduciary? Within a 401k plan, you have various people that would not be considered fiduciaries. They are commoditized assets. So you are the plan sponsor. You hire Bob Broker. Unless Bob Broker puts it in writing, he is not a fiduciary. You are by yourself. Bob Broker, if you have a 401k plan, you will need a record keeper. A record keeper, I mean, essentially they are all accountants, but they are not considered fiduciaries. They are purchased, they will do your testing, they will do everything for you, but, and be accountable for those things that they are. If there's nothing wrong with your plan from a structural point of view, it's from a management point of view, not their problem, have a good day. And then there's the investment managers behind it, the mutual fund companies, things like that. You are essentially responsible through your advisor as to what companies are being picked, but that doesn't necessarily mean that, you know, there were all aggressive funds in my 50-plus-year-old plan. It's not the mutual fund's fault that they were selected. They have no, I mean, they were bought. They are essentially and will always be the Buick dealership. And part of what we hope to have as the foundational piece of your document is the roles and responsibilities of all parties are documented in the IPS. We want our advisors to be co-fiduciaries. The Department of Labor is going to insist on it. And I believe that because of that, there's going to be a contraction in the number of advisors that do administer 401k plans. You work for Wells Fargo won't let you. Merrill Lynch won't let you. It will be the domain of a lot of independent advisors that don't, as I mentioned before, enjoy the same licenses that you would traditionally want for somebody that is overseeing that type of plan. All parties demonstrate an awareness of their duties and responsibilities. That means annually, anybody that is responsible for that plan, you go and you get letters from them saying that we are just reaffirming your co-fiduciary status, your role in the plan, and this is your duty. Some companies have a board that decides their various processes for, you know, who are we going to have for employee benefits, and of those employee benefits, it's not just health care, it's the 401k as well. Each of those people that is on that board that decides is a fiduciary. Whoops. They might not know. They might not know what they're looking at and just pick the one that has the prettiest cover. That's why board education, employer education is so very, very important in this regard.